Every era has a new craze that just sweeps the country like a plague of locusts, absorbing followers into the cult and forcing the rest of us to coexist and deal with it. Now, unlike dances and music groups that eat your soul at every wedding that you go to, this problem we're talking about today deals with your rights. With already 5 states on board and more soon to follow, this is destroying the Second Amendment. The Supreme Court just accepted this issue, and I hope and believe that they will knock it down before it spreads. I've been warning you about this for years. What is it? We're going to go through some of the Department of Justice's arguments against it and why they should be struck down. Guys, let's get into it. We are talking about the private property default rule. That is a sweeping affront, not only to the Second Amendment, but just to property rights in general. And it functionally bans ordinary law-abiding citizens from carrying firearms in public against the Second Amendment, against what the Supreme Court has ruled across multiple cases now. And it could be coming to a state near you next. What does this law do? This law reverses a centuries-old presumption of liberty. You see, historically, Americans have been free to carry firearms on private property that's open to the public, unless the property owner objects. So in other words, I can carry a firearm into a store, into an office building, whatever else, unless they object. One of the ways they can object is they can tell me. Another way is that they can properly post it depending upon what state you are in. That's the way how the game is played. Well, under Hawaii's Act 52, property owners lose that choice. Now, property owners have had the government make the choice for them because the government decided, no, you actually don't want people carrying firearms here. You don't want people exercising their rights here unless you opt in. Imagine if that was the case for the First Amendment or whatever else, right? You don't have free speech unless that store owner, the shopkeeper, the office building manager, whatever else, posted a sign that says First Amendment okay here. That's literally what we're talking about, without exaggeration, except instead of the First Amendment, we're talking about the Second Amendment. Hawaii and other states are claiming that they have the right to do that. The Trump Department of Justice, as well as the plaintiffs, are saying, no, you don't. Now, just to kind of twist the knife and make this worse, in my experience, and I haven't looked at every single state and analyzed all of their laws. If you want me to do that, let me know down below in the comment field. But generally, the ways that these are passed and enacted, it's not just a question of, yeah, we're going to do it just to these particular spots or something like that, where it's only, I don't know, public park buildings from 9 p.m. to midnight the third Tuesday of every month, right? I mean, you get the idea, but it's never that. It's always very broad, very sweeping, that amounts to a near complete ban on public carry, which of course is the whole reason why they are doing that. They are criminalizing, intentionally criminalizing, the mere exercise of a constitutional right. Never mind the fact that, of course, criminals won't care. You're only disarming the victims. But, right, I know that the people who need to hear that, they aren't watching this. So I'm just going to, for you and I'm just going to soldier on. So the Department of Justice, in what's called an amicus brief is a friend of the court. So in other words, they're not a party to this case. They're not the plaintiffs. They didn't sue and they weren't the ones being sued. But they filed what's called an amicus brief that argues that such a radical invasion defies, this is their wording, defies, indeed effectively nullifies the general right to publicly carry arms that Brune recognized. Brune was that June of 2022 U.S. Supreme Court case that said that, you know, you can't do this. That's the too long did not read version. So let's go through some of the core constitutional faults here. There's no historical tradition or legitimate purpose. The Supreme Court in the Brune case held that any regulation on carrying firearms, really the Second Amendment, core Second Amendment activities, which certainly includes carrying firearms, must fit within the nation's tradition of firearm regulation. And that tradition, by the way, does not start in the year 2020, okay? We're talking at a minimum back in the 1800s. And if you're anti-gun, you want it to be closer to the year 1900. And if you're pro-gun, you want it to be closer to the year 1800. And that's just, again, that's the long story short. And it has to be representative of that tradition. It can't just be one little podunk municipality somewhere did this, and therefore we can just export it across the whole country in 2025. Not the way this works here. It has to be representative of that tradition. And in a nutshell, Hawaii's rule is not that. It singles out firearms for uniquely burdensome treatment, according to Trump's Department of Justice. Again, we're reviewing some of their arguments on private property, but allows any number of other items, umbrellas, megaphones, alcohol, dogs, without special permission. In law and tradition, property owners have always had the right to exclude firearms, but never before has the state presumed a universal exclusion rule, criminalizing carry unless explicitly allowed. And I suspect the reason why the Trump administration talked about umbrellas, megaphones, alcohol, drugs is because umbrellas, if you're coming in from the rain, they can be wet. You're going to be making the floor wet. That creates a nuisance. That creates a hazard for slip and fall injuries if you've got a linoleum floor. Megaphones, alcohol, dogs, loud, disruptive oftentimes, right? We don't see the government getting involved in those things that foreseeably does cause problems. Slip and falls, disorderly conducts, bad bets on football, whatever else the case might be for alcohol. And dogs, well, poop on the floor, I don't know. Take your pick. You get the idea. Dog bites, whatever. They aren't for everyone. I've got 3, but they may not be for you. And their point here is that they're picking on a constitutional right to start to make this application. You don't get to do that. They also said that this is discriminatory and an arbitrary application. The law imposes a far higher burden on property owners wishing to allow guns on their property versus those wishing to restrict them. Because if you wish to restrict them, you just don't do anything. So imagine that. What they're basically saying is if you want to allow the Constitution and allow people to exercise their rights, you've got to go out and buy a sign, make a sign, figure out what the law is, figure out how to comply with it, what are the postage requirements, you name it. Owners can only authorize carry by posting clear and conspicuous signage or giving unambiguous written or verbal permission, but mere inaction, silence, or an approving nod is not enough, even if it would suffice for other forms of consent or items. They also argued that it's a functional ban, something I already hit on before, but I do like one of their quotes that I'm going to be covering here. This is a functional ban, not a regulation. By making firearms carry unlawful in all private spaces, open to the public unless explicitly permitted, you've created a scenario that is exceedingly rare, one where the law amounts to a ban on everything and everywhere, but by name. The brief notes, quote, because most owners do not post signs either allowing or forbidding firearms, the rule effectively means that ordinary citizens may not carry firearms on any private property, even property open to the public, end quote. This impacts daily life. Law-abiding citizens cannot get gas, shop, eat at a restaurant, or park their car with a lawfully carried firearm subject to whatever the local laws might be. Hey, please excuse this brief interruption to bring you a word from our sponsor, me. Or more specifically, my law firm. You see, what you may not know about me is I'm not only an ex-prosecutor, criminal defense attorney, but I employ a few dozen attorneys all over the great state of Wisconsin. My firm handles criminal defense, traffic law, divorce, family law, as well as estate planning all across the dairy state. We've got different wings of different attorneys doing different things, so you don't have to have some sort of just generalist handling your case should you decide to come in. So what's the ask? Well, look, if you've been with me for my journey of at this point about 10 years and counting, not all of them on my own YouTube channel, but about 10 years and counting of putting out free legal education content that's out there, first off, thank you for joining me and thanks for watching this video. And if all you can do is just keep watching, hitting the like button, sharing it around, commenting, thank you. And I really do mean that. However, if you want to take it one step further, please consider following the directions below, both in the description box as well as in a pinned comment down in the comment discussion field about how you can leave a 5-star review. So again, if you can do that, I tremendously appreciate it. Not only myself, but everyone else want to thank you for doing that too, because it helps us bring our mission across Wisconsin. Don't forget to stick around to the end of the video for our ever popular quote of the day. Now back to the show. We've got a direct conflict with federal precedent in another circuit. So in the Second Circuit Court of Appeals, we had a case that I covered here, Antoniuk versus James. We're talking about New York now, which the judge struck down. The judges in the Second Circuit struck down this government choosing and how your property runs by default Okay, the Ninth Circuit Court of Appeals, however, this is where this case came from going to the U.S. Supreme Court. The Ninth Circuit said, nope, the opposite. This created what's called a circuit split. This is, if it's an important enough issue, this is exactly how you get the Supreme Court's attention. The Trump administration and the DOJ also argued that this is a foundational, important issue for nationwide gun rights. Why? Because we're only talking about Hawaii. It's not like you just accidentally walk into Hawaii if you're not from Hawaii, if you don't live in Hawaii, right? Yeah, but more than 20%, more than a fifth of the nation's population now lives under regimes, under regulatory regimes, under laws that have adopted Hawaii's logic. So this is not something that just impacts a few people. This impacts a lot of people, and presumably more states are going to be adopting it. We already have New York judges and the Second Circuit Court of Appeals threw this out. Ninth Circuit said that it's in. Now we've got a situation where there's just mass chaos about what's going on legally here. This is where we need the Supreme Court to just come in and drop the hammer. And I think and I hope that that is exactly what the United States Supreme Court is going to do. Be sure to hit that like button, the share button, and let me know down below what you think is going to happen. Place your bets. Go on the record here with me. I want to hear what you have to say. Our quote of the day comes during the Massachusetts Ratifying Convention of 1788. I believe this was Thomas Jefferson. Someone fact check me on that if I got that wrong. Quote, "And that the said Constitution be never construed to authorize Congress to infringe the just liberty of the press or the rights of the conscience, or to prevent the people of the United States who are peaceable citizens from keeping their own arms." When I say the Massachusetts Ratifying Convention, we're talking about ratifying the United States Constitution here. The United States Constitution. And this predates the Second Amendment. The Second Amendment got ratified in 1791. So they were talking about gun rights being baked into the pie way outside the Second Amendment here. Just a little pro tip for you to drop on your friends. You got holidays coming up. Time to zing that ant of yours, right? Appreciate you sticking around. We'll see you in the next one. Take care. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.